Alrighty, we are back. Thanks for staying with us. Planet Green Shoes, episode number 393. Seems like it should be more. All right.
No, we've skipped a lot.
It's fine. We decided to break off of the 5 hours of relaxing psychedelic space rock and return to the topic at hand. What were we talking about again?
We were talking about
I know exactly what it was.
The initiative and the significance of the legislature passing on enacting it.
And the Republicans' role in that.
Right. Well, there's two things that kind of I raise. This is what I'm saying. If the regulate marijuana like alcohol passes, it's a voter initiative. Legislature passed on that. They did not pass, however, on regulated medical marijuana.
That is true.
I say that, contrary to the previous argument that nothing has been done to amend the public health code, I say there has. And this includes, if the amendment passes, it means that the voters have determined, not just for medical reasons, but for all adults, that marijuana not be considered illegal as it is prohibited in the public health code. So there's an intention there that applies to the exact things within in all the classes of individuals that would be subject to the public health code, right? That's an argument?
Right, and since it's a people's enacted initiative or legislation, it pretty much overrides the public health code because that was introduced and initiated by the legislature.
Understood. Is there a conflict resolution? There's not.
I'm pretty I'm not sure.
We gotta look at that.
There might be.
Nevertheless, it could still potentially be in conflict, but we could understand that in order to, unlike, like the interpretations of the MMA have been under the auspices of trying to implement a law and the intentions of the voter initiative. And likewise, if there's challenges to the treat marijuana like alcohol, the courts will allegedly try to interpret it the same way. But the question really, when you stand back and look at it, and even, what was the purpose of that, of the MMA? In its most progressive liberal interpretation, maybe something like, what's the best interpretation you get out of it versus, I'm not saying things that, what it says, just versus what's the limitations to it. Like, for example, we know that there was an argument made at one point that the MMA did not have an affirmative defense if you violated any aspect of it, including Section 4. Nobody thought that was going to be the case, right? So there was going to be two aspects of immunity and a affirmative defense that said it. But what would be, what would be the worst, most, expansive interpretation that you could offer some of these defenses that, what the MMA meant? What would be the most expansive that never got any traction because the judiciary that was in line and the way the issues were framed by whatever prosecutors, and the politics involved in it, like
People v. McQueen.
That's one. You got all of them. You got the doghouse with the king and Kalanick, and so the point is, though, the point I'm trying to make is there's circumstances that brought that to be, and as these cases went forward, they narrowed and limited the blanket of protection, not just to the behavior, but the individuals. And they were extrapolating from that what seemed to be whatever the underlying intention was. And I don't think anyone denied that for certain class of individuals, protections were offered, not everybody, right? But people with cards was the idea, or people that had a recommendation, some capacity. All right, so with that being said, can we really say the same thing about this treat marijuana like alcohol? If the point of this is, and the underlying core is to penalize by fine, right? That's really what it is. You're outside of the regulations. It is not that you opt out of those protections. It's that's the intention. So that's different. That is not a stretch, right? That's not extreme to suggest that this voter initiative in its end game is to not treat marijuana like it has been, right? It's not to be treated as if it is a controlled substance. They're going to treat it what seemed to be more like a regulated spirit, or
Yes.
whatever you call it. So, and I don't know how those intentions, writings, analysis, comparison to something that's so clearly identifiable would be anything other than an intention to undermine, vitiate those prohibitions in the public health code. That's what I'm saying. I need an argument for that. Now, I think another argument could be made that we're already there. What? We don't even have legalization that hasn't even passed yet. Then we may already be there. Why did I say that? Because, we've talked about this in the past, but the idea right now, as we sit here, that the smell of marijuana can be considered contraband per se, and that a search warrant can be issued if articulated in an affidavit signed by a affiant or detective who says that he knows what marijuana smells like, without having to provide any other information, will issue a search warrant. With that being said, and that's the law, that's the way it's being interpreted in courts, as if nothing has changed. The logic and reasoning behind this is that marijuana is a Schedule 1 or maybe a Schedule 2, maybe, for medical purposes. But it has to be in one of those two categories in order for it to be deemed dangerous. It has to be in one of those two categories that the sense of it, presence of it, would be so harmful, scary, and unjustifiable in having that it warrants issuance on the smell or presence of it alone without anything else.